and welcome to a newsflash episode of Unpacking the Case, the podcast by Davitt Jones Bould, the real estate law specialists. As always, I'm joined by our head of legal training, Richard Snape. Hello, Richard.
Hello, Lizzie.
So we're here for another newsflash podcast. This time, a decision from the Court of Appeal from the 25th of July, which was confirming an earlier upper tribunal decision. And the case is called AP Wireless 2 and On Tower, and it's all about the requirements before you can have a lease and the significance of that. So do you want to start, as usual, with some background facts, please?
Yeah, it's about many things, Lizzie, and it's pretty significant as well. But I don't understand the reasoning of some of the decision, I have to say. And it brings in a lot of land law and took me back to my days when I was a land law lecturer, just a child land law lecturer many years ago at university. And also, it seems so many times on these podcasts, I know the place where it all took place. It's a place called Fields Farm, and it's on the Congleton Road out of Sandbach. Do you know it?
I don't.
It's
unsurprisingly
not that far from where I live. And I shall go and have a look at it this afternoon. It was a communications mast. I mean, the AP Wireless and On Tower were both assignees of the original, sort of people who agreed this particular agreement for communications equipment. And ostensibly, it's about communications equipment, but it's about so many other things besides. It's fundamental to the landlord and tenant. Back in March the 11th, 1997, the original parties had agreed an agreement. It wasn't called a lease, but a minimum term of 10 years from that date, from March the 11th, 1997. And then after 10 years, it could be terminated by either party on giving the other no less than 12 months notice in writing, which could expire no earlier than the expiry of the minimum term, so expiring on the 10 years. And at a later stage, one of the parties On Tower, who were the operators, wanted to argue this was a license, and AP Wireless wanted to argue it was a lease. The reason they wanted to do so, I say it's not just about communications equipment, which is very, very specialist stuff, but if it's a lease, and the agreement was entered into prior to the Digital Economy Act coming into force on December the 28th, 2017, then any renewal would be under the 54 landlord and tenant Act, where you get a higher rent and the likes, more favourable to the landlord. Whereas if it's not a lease but a license prior to that date, then, many things apply if it's a license. But the operator could use the Communications Act, the Electronic Communications Code, the Schedule 3A nowadays of the Communications Act, to go through a much more favourable renewal for themselves. So that was the reason it became important. But I say the idea of whether it's a lease or a licence is obviously important in many other respects. So what are the requirements for a lease? Well, it's been talked about over many years. You've got to have exclusive possession before you can have a lease, to exclude all others from the land, including the paper owner, the sort of the landlord themselves. The thing was railed off and the likes. It was accepted there was exclusive possession. So in this particular issue, that didn't cause problems. You've got to have a rent, and they were paying a yearly rent. It was calculated on a yearly basis, payable quarterly. So that requirement's there. But it's got to be for a term. It's got to be a fixed maximum duration. You can't have a lease if it's of uncertain duration. So they didn't really deal with this, but it's what distinguishes a leasehold estated land from a freehold estate. Freehold is of uncertain duration. Fee simple, which passes to your successors and the likes until you have none and goes back to the crown, or life interest and the likes. And a lease, which could be a 3-month lease or a 3,000-year lease, but it's got to have a fixed maximum duration. And that's not the thing in question. Does that term that either side can terminate no earlier than by 12 months notice, no earlier than the initial, after 10 years, is that is that a fixed maximum duration or not?
So what was decided in this case?
Well, there were various arguments put forward by the owner of the land and the various cases which were discussed. Firstly, as to whether it's a fixed maximum duration, that provision. There are quite a few cases that I would have discussed that weren't discussed, actually. But they cut a long story short. I mean, for instance, there was a case that no one can deny was sort of gave rise to a problem and wasn't at least. It's a case called Lease and Chandler in 1944, which was a bit of a test case for quite a lot of agreements which were stated to be for the duration of the Second World War, which is, when it starts, is the important issue, was uncertain in its duration. When it is the start point that matters, is the one that's it's uncertain in duration. It actually gave rise to a piece of legislation called the Validation of Wartime Leases Act, which converted them all to 90-year leases, but that's a bit of history now. I suppose they're still in existence, some. But so that was the first issue. I mean, I always thought the most important case, but Court of Appeal didn't necessarily agree, was a case called Prudential Assurance in the London Residuary Body. It was a House of Lords case from 1992, which was where the predecessors to the original agreement, it was that a piece of land was, you were paying yearly rent for it until it was needed for road widening. And the House of Lords decided that that gave rise to, uncertain duration. You didn't know that, at the very beginning, how long it was likely to last, so it couldn't be a lease. But they went on to say that because you were paying the rent yearly, it must be inferred, there wasn't some sort of fixed duration, but it must be inferred that there'd be a periodic tenancy, a yearly periodic tenancy. And if you've got a yearly periodic tenancy, you can give at least 6 months notice at any time terminating the period of the tenancy. So that sort of became something totally different. There was also a case called Mexfield Housing Cooperative, another Supreme Court case from 2011, which said they agreed with Prudential, but basically, parts of it they didn't. That was all about a housing association agreeing a monthly tenancy, but they could not give notice unless the tenant fell more than 21 days in arrears with their rental. And because both sides need to know, you need to know from the very beginning what the notice periods are, then that was held to be of uncertain duration and couldn't be a lease. But they then decided that it became a life interest. And if you remember, anybody in their degree level studies, it's converted by the Section 1496, subsection 6 of the Law of Property Act into a 90-year lease, which can be terminated on the death of the tenant. But what about here? Well, the Court of Appeal decided that that clause we mentioned was made it of uncertain duration. I take issue on that, actually, but that's what they said. They also said there was no express periodic tenancy. There was no suggestion of an express periodic tenancy, which are still of certain duration, because at any time you can give notice, at the end of the period of tenancy, if you like. But they also decided that they'd be hard pressed to decide there was an implied periodic tenancy based on the fact you were paying the rent. And therefore it's a license. I think that flies in the face rather of Prudential and London Residuary Body. But that's what they said. So it was a license and not a lease. Even though you've got exclusive possession and a rent, it could still be a license.
Why do you think that decision is significant?
It's significant because that clause is commonplace, not in communications mass. But it's a good way of avoiding the 54 Landlord and Tenant Act. And you've very recently, done a podcast on the fact that the government's plans to ban upwards only rent reviews in 54 Act leases. That's a huge way out of it. But I say I've got question marks over some parts of it. I mean, it's not exactly to the point, I admit, but we did. Do you remember just doing one of those fundamental land law cases? Walsh and Lonsdale, 1882, 7-year lease, which didn't have the legal formality of a deed. But the court decided it was still an equitable lease, and it was also a legal periodic tenancy based on how you pay the rent, but equity prevailed. There's a case called Goodman and Everly, which was a 1-year fixed term tenancy and thereafter from year to year. So it's a kind of thin line, really, but we'll see. And it's highly significant.
Well, thank you very much, Richard.
Okay, thanks, Lizzie.
Thank you very much, Richard, and thank you to everybody for listening. We'll see you again in our next episode.